But what I'll do is I'll hang around, so if anyone has any questions, feel free to ask, or you can always call me. I'm pretty easy to get in touch with. Okay, surface use agreement. Because of the visibility of estates, the dominant estate, the mineral estate, the surface use agreement is traditionally used to address functional issues involving the land itself. Okay? Now, one thing you may ask right off the bat is, Ralph, if the minerals and the surface are owned by the same person, should we do a surface use agreement? And the answer is that's the better practice. You don't need to, because surface use issues can be addressed in the oil and gas lease when title is unified. But even if title is unified, there's nothing wrong with doing a surface use agreement above and beyond an oil and gas lease. Now, if the minerals are severed, it's incumbent that you attempt to enter a surface use agreement. It's just a contract, so you got to negotiate the thing, and different entities provide different challenges, let me just say. But typically, the types of things we're dealing with in a surface use agreement would be things like, what are we going to do involving the use of the roads? What are we going to be doing involving the fencing? If I've got, I'll give you an example of something I was working on this morning. I got a client, he's out in Craig. He owns the surface of a Section 16 school section. And he also owns other land around it. Well, the Section 16 school section, he owns the surface but not the minerals. They're leased out by the state land board. And now they want to get into development. And they've gone out, the developer, they staked some property, we've had some surveys, and we're negotiating these types of things. My client has a guide and outfitting business. So we are negotiating exclusionary periods where, absent an emergency, the oil and gas operator can't come on the property to do any drilling. He's got certain areas that have very, very high producing alfalfa crops. So we are identifying areas where they cannot go in and set up a well pad. There are rights of ways that are coming across the property to service wells on his property, or a well and future wells, and then some other stuff. So we're negotiating the right of ways, including things that you wouldn't think about. He's having a big problem because he's got the machinery for the alfalfa. Well, if the rocks get too big, they get thrown out from the road. It wrecks his equipment, and don't wreck it, but it idles it. When you're cutting hay or alfalfa, man, you got to get that stuff cut and put up before the rains and everything. He's out there and he blows the blade. Now he's got time down. Okay, different client. There's a producing well. Now you've got battery tanks and things like that. We negotiated a revegetation plan because she doesn't want to look at that stuff. She wants to look at pretty trees, and we did that. Cattle guards and cattle gates. If you're coming across my property, that's fine, but let's do this. Let's make sure the cattle guards, so they're not wandering around. We don't have to do gates, but in the wintertime, cattle guards aren't going to do us a whole lot of good. So you go in through those things. What type of gates? What type of fence? Not all fences are the same. So when we talk about surface use agreements, those are some of the things we talk about. As we're talking about too during the break, this is where the water use issues become huge. Because if I own the surface, the last thing I want is the oil and gas producers to come and do anything to compromise my water source, whether it's for domestic water or just irrigation water or whatever it may be. So we put provisions in there about don't be using my water. We're going to test the water. We're going to test the water at the onset. We're going to test the water regularly. We're going to test it for the quality of the water and the quantity of the water. So, you know, we get into all those things. If anyone's really interested in surface use agreements, go to my website, go to the publications area. There's a publication we did a couple years ago on surface use agreements. It's just www.kentuckylaw.com. It's right here on the first page. There are a couple different articles in there. That's one of them. But surface use agreements are hugely important in a circumstance where you're representing someone that just owns the surface, okay? And that's why, you know, go down this list. I don't know if I said this, but what I want you to do is, if you're in a situation where you're listing a property or selling a property, particularly an ag property out in the county, you know, just ask them, is there an oil and gas lease? If so, I need to see it. And even if they think it's expired, say, I need to see it. You know, get the documents. Surface use agreement. It's like, look, if there are going to be restrictions on the surface because of the oil and gas leases, we need to see that. Seismic agreements. You know, typically what will happen, the very first phase of all of this is seismic crews will come out and they'll lay cables, they'll do dynamite, there are different ways to do it, different helicopters. But typically that's a form of trespass without a contract. Okay, so you want to know. It's like, hey, just checking, is there a crew coming out? Because the way it works is geologists come up with a plan, they work with the seismic team, they come back, you got to go through the county, you got to get your permits, then you got to get everything arranged. You know, typically, this is a process that takes several months. So it could be the type of thing that, you know, you're listing a property and, you know, your client's not even thinking about it, but there could be an agreement to do seismic, and that seismic can create problems, okay? I mean, the seismic can be destructive. It can affect waterways. It typically doesn't, but it can, okay? So you got to ask, hey, is there a seismic agreement out there? Are there any recorded rights of ways or easements? I mean, that's going to apply whether or not you're doing oil and gas or not, but you know, you need to know up front because, you know, those things can be very, very picky. I mean, it's really what I call a sensitivity issue. I mean, I get some clients that they could care less. I mean, you could run a team of Harley Davidsons up and down the road. They could care less. And then you got the other client that's all bent out of shape because, you know, little Ralph has his bicycle that he goes through, you know, once a week. And, you know, they think it's a form of trespass. So make sure you know the rights of way and the easements and things like that. Water use. You know, is there a well permit? And I gave you the website where you can look it up in case you don't know that. But, you know, you need to know, is there a domestic well? Is there irrigation wells? You know, what's going on? You know, it makes good sense. Appropriated rights, I mean, water courses and things like that. You know, what's the water right? What's the beneficial use? How do we do that? Then, you know, key, COGCC, Colorado Oil and Gas Conservation Commission, great website. If you're doing this stuff, you may want to get on and find out, hey, is there a well permit pending? Or more importantly, is there a well permit pending within a mile? Because you want to make sure that you're aware of the permit activity. And the reason I say that is, you know, we want you guys to look like rock star A+ brokers. You need to know that stuff because, you know, the last thing you want to do is find out you're selling the property and you're getting negative feedback because people are saying, look, this is right in the middle of a major play. Okay, you want to know that before you list the property. I'm not saying you don't want to list the property, but you know what? If that's going to be an issue, if that's going to be a problem, you want to know that ahead of time. You want to know that before